Yes.
If the respondent succeeds in proving that petition number 2 is not his daughter, then he is at liberty to file application for modification of the order. We are ready to pay the amount from the date of the order. That is all the question, my lord. If it is from the date of the petition, I have to pay nearly about 18 lakh to 20 lakh. That is, my lord, he is getting 6,000 salary in working in a local milk union.
How much your salary is?
6,000. So paying 18
Then
lakh.
court had granted 10,000, why you didn't question it? As far as this petition is concerned, that order of the learned judge in the revision has attained finality.
Yes, it has attained finality.
That this court cannot grant any concession to you in this.
The respondent has filed earlier CMS number 378 of 2013. The same was dismissed by the order dated 13-2 to 13-2.
Where is the impugned order?
It was dismissed on 13-2-2004. My lord, against the said judgment, my lord, a revision petition is filed at Annexure D, page number 26.
No, please tell the facts. Who are you? You're the wife or the husband?
My lord, petitioner is the husband. Respondent number 1 is wife, respondent number 2 is daughter. CMS number 1, earlier CMS filed for maintenance has been dismissed by the order dated 2014.
Again, is that RPFC?
RPFC is filed. In RPFC, a categorical statement defense has been taken. The paternity of the second respondent has been denied. At page number, my lord, may kindly peruse at page number 33. That is the operative portion of the order.
33.
Yes, 33. It will start from 32, my lord.
Yes.
33, last para.
Yes.
If the respondent succeeds in proving that petition number 2 is not his daughter, then he is at liberty to file application for modification of the order. My lord, in original suit, a DNA an order has been passed for DNA test. We are awaiting for the report, and at very shortly that will be decided. Meanwhile, my lord, they have filed an execution petition for recovery of the amount from the very date of petition. We are ready to pay the amount from the date of the order. That is all the question, my lord. If it is from the date of the petition, I have to pay nearly about 18 lakh to 20 lakh. That is one aspect. Secondly, if the paternity of the child is, I am able to prove it in the original suit, then I cannot go for recovery of the amount. So, we subject to, my lord, the payment of the amount from the date of the order passed by this honorable court.
When is the date of order?
And at page number 26, my lord, 13-2-2024.
How can this order?
This is the High Court order. Page number 26.
What is granted is?
My lord, 5,000 to each respondents at page number 32.
No, as far as the wife is concerned, you cannot seek for it.
Yeah, wife is concerned. For my lord, the thing is, wife also working is the contention taken by the petitioner. My lord,
whatever it is now, if you want.
My lord, High Court does not order from the date of petition. It is just allowed the revision petition, and liberty is given to the petitioner to recall the application with respect to daughter.
When it is not specifically said, we have to assume that it is from the date of petition.
My lord, a huge amount, 18 lakhs. So,
the wife you are liable to pay.
My lord, he is getting.
You have not questioned this order on the revision.
We have not.
It has attained finality.
It has attained finality.
That wife is entitled from the date of petition.
My lord.
And there are no reasons to stay that order.
My lord.
So, as far as the son is concerned.
Daughter.
We'll record that as far as the son is concerned from the date of order.
Daughter.
For the wife is concerned, you have to pay, will not grant stay.
My lord, he is getting 6,000 salary in working in a local milk union.
How much your salary is?
6,000. So, paying 18 lakh.
Court had granted 10,000, why you didn't question it? So that shows.
I have to go to Supreme Court, my lord. His financially is not in a position to question that.
But he has to pay ultimately. That order is not questioned.
My lord.
And you kept quiet from February.
My lord, to limited extent, my lord, it was subject to deposit of some amount.
We have to grant stay on some basis.
Some amount.
Not that. No. As far as this petition is concerned, that order of the learned judge in the revision has attained finality.
Yes, it has attained finality.
That this court cannot grant any concession to you in this.
My lord, there is no specific order from the date of petition. So it is a presumption is from date of order is my submission.
Generally, or wherever there is an order, it will be from the date of petition, unless and until court specifically says that is from the date of order.
My lord, otherwise you will be arrested and you will lose the job also. Entire livelihood will be affected, my lord. That is the,
But please understand
Yes,
what
I
is that the
understand,
court can
madam.
do.
I
Now, with regard to your second submission, that it should be from the date of order.
leave it to
As far
her.
as the wife is daughter,
So
that
this is the circumstances and the difficulties.
we will, but we can't.
Yes, please.
No, which order is questioned?
My lord, we have questioned the order overruling the objection filed by the petitioner at page number, sorry, at page number 25, my lord. Our objection has been rejected. Our main objection is we are liable to pay from the date of the order is the objection we have raised at page number 13, annexure B. And a recovery also from the every year recovery application has to be filed.
Unnecessarily, why the court should interfere in this?
My lord, as far as the daughter is concerned, my lord,
Is it not that the court is in, by passing any order in this, court is encouraging unnecessary litigation?
my lord, my objection has been rejected with respect to
No, while exercising jurisdiction
yes.
under 227, what is the scope of inquiry? Or the adjudication by this court?
My lord, as far as the daughter is concerned, my lord, that will be even very shortly the original suit will be decided. My lord, if I am not able to succeed, then he is liable to pay. That is a different aspect. So just we are
Court
awaiting.
notice will not, as far as
Yes.
the recovery in respect of son only is state.
Daughter.
Daughter, the learned counsel for the petitioner submits that the court had granted the maintenance of 5,000 to the wife, 5,000 to the daughter. He submits that he is questioning the paternity, and already DNA test is ordered and they are awaiting for the
In OS number 36 of
awaiting for
2013.
the report. He submitted that. In the meanwhile, they have filed the execution, and if the entire amount is paid, it will be difficult for him to recover it. Even according to him, the wife is also earning. Earlier, when criminal MC is filed by the wife and daughter seeking maintenance, when it was rejected, they have come before this court. And this court, by order dated
13 to 2024.
by
Page
order
number
dated
26.
13 to 2024, I had passed an order wherein 5 months, 5,000 to the wife and 5,000 to the daughter is granted. It is also observed by the court that if the respondent succeeds in proving that the daughter is not his daughter, then he is at liberty to file application for modification of the order. The petitioner, when he has not questioned the order passed in RPFC number 192 of 2016, dated 13th February 2024, whether the wife is working or not, and working or not, and whether she's entitled for maintenance, those issues cannot be gone into. But as far as the daughter is concerned, considering the submission, this court is passing the following order. 1, the petitioner, as far as the maintenance, as far as the wife is concerned, this court is not interfering. Then when it comes to the case of the daughter, the petitioner shall deposit the amount from the date of the